Hi everyone, my name is Lena Nguyen. I'm a family law attorney licensed in Texas and California. Today I'm going to be talking about what is considered your own separate property. In a divorce, the character of a property becomes an area of assessment when it comes to dividing assets. The character of a property refers to whether the property is separate or community. In other words, does the property solely belong to one spouse, or is it part of the marital estate and is subject to division? The following is a list of property that is considered to be separate property. Number 1, property acquired before your marriage. Property that you acquired before the date of your marriage is separate property and is not subject to division. Number 2, gifts. Gifts are separate property regardless of whether you received the gift before or during your marriage. Number 3, inheritance. Property you acquired through a will or inherited from a family member is separate property. Number 4, personal injury recovery. Compensation you receive for personal injury, whether before or during the marriage, is considered separate property. This includes recovery for bodily injury, mental anguish, and pain and suffering. Number 5, agreement. If the property was acquired by agreement, it is considered separate property. There are 2 types of agreements that fall under this rule: partition and exchange agreements and right of survivorship agreements. So a partition and exchange agreements are created when spouses actually agree that certain property that is already acquired or they will acquire will remain separate property. Right of survivorship agreements are created when spouses agree that all the property listed in the agreement will become the separate property of the surviving spouse after the other spouse dies. Number 6, property purchased with separate funds. If you spent your own money and resources to purchase the property, it is considered separate property. However, you must be able to prove the property was purchased with separate funds. Number 7, property purchased with separate credit. If you used your own credit line to purchase the property, it is considered separate property. However, you also must be able to prove that the property was purchased with your own separate credit. Number 8, income from spousal gifts. If you received a gift from your spouse, any income that is generated from that gift is considered separate property. Number 9, property purchased from separate property and both spouses' names are on the title. So if one spouse purchased property using their own separate property, but titles the property in both of the spouses' names, it is presumed that the spouse intended to gift a 1/2 interest in the property to the other spouse. Number 10, property purchased while living in another state. In Texas, there's a rule that is often referred to as quasi-separate property. It is in essence separate property and it's treated as such. So if all of the following factors are met, the property will actually be deemed separate property. Number 1, there's a divorce that's pending. Number 2, you're living in another state. Number 3, you purchased property in that state. And 4, the property would be considered separate property in Texas had you been living in Texas when you acquired it.
Thank you so much for watching. Please give this video a thumbs up and subscribe to my channel. Also, if you live in Texas and would like a free self-help divorce kit, please check the description box below to sign up.